that's kind of an objective standard, but I came up with it, so maybe it's not so reasonable, all things considered. But the other thing I just wanted to note, I wanted to piggyback on an issue that Tom Green raised, and that was about supervision. One thing I noted was that the Pearson Butler, I went in and I looked at a number of these applications, and I highly recommend you take a look at the, everyone take a look at the Pearson Butler order, and the application is attached to it. Or not the application, but I think the
recommendation.
The office's summary of the application that went to the Supreme Court for the Supreme Court's approval. It's fairly lengthy, it's about 80 pages. But I think one thing in it they talked about, they wanted that the supervision rules of lawyers were sort of tentatively suspended because they were still trying to work out the supervisory responsibilities between the different subgroups within Pearson Butler, because it was going to be kind of a multidisciplinary practice that's going to be providing both financial services and legal services. And I think at the time of the application, maybe I'm incorrect, and maybe this has been resolved since then, I got the impression that they had not yet worked out the details of how they were going to go about supervising and whether they would have to go back again and get approval before they would give full approval to provide the services in the entity that they had laid out. John, are you familiar with that particular application?
Sure. And what happened with Pearson Butler, and it's happened with several applicants, is they sort of, if you will, ask for the moon. They ask for this larger range of things. And it turns out when you have an iteration with them and have an exchange with them, you learn that they're really only ready right now to go so far with A and B, and C and D are still, wishes and hopes they have and gleams in their eye. We would only authorize them for A and B, and then work later with them to the extent they got ready to consider authorizing them for C and D. In the case of Pearson Butler, that's kind of where they were. They had the non-lawyer ownership piece that we could look at, but they didn't have the supervision of non-lawyer services particularly well developed. So they weren't authorized for that in the initial instance.
Great, thank you. That's all I have.
Thank you. Ms. Alkenbrack.
I have a question for John as well. If I'm understanding you correctly, the order or whatever is given to the entity in the sandbox, does it actually spell out the particular rules of professional conduct that they're exempted from? Oh, it does. So advertising or 5.4 or whatever it is, depending upon their unique model or vehicle or business entity that they're putting forth, it actually spells out what they're exempted from.
Right.
Does it also say then that the attorneys that are acting within that entity, that particular entity, are not exempted from the rules of professional conduct?
I'm just looking to see if we see one of our orders. I think there's some language says, you're exempt in this purpose, but you're otherwise, continue to be required to otherwise comply with the rules. But it may be, to Kevin's point, that that's just sort of the underlying assumption that would operate. I'll have to check that, Marta. I don't remember how that language works.
It might be helpful if those materials, if you have some of that, and even the Pearson Butler stuff could be submitted to the state bar liaisons and then distributed to us. I think all of us here would be interested in looking at that kind of material.
I'll pull a couple of examples of those orders and give them to the staff.
Thank you.
That's super. Thank you. May I make a suggestion to broaden the proposal that I think you articulate, Mary, in terms of what lawyers continue to be obligated to do unless specifically exempted, that we would broaden it to include any sort of legal professionals, which is a very small category right now, but would grow if we had a licensed paralegal program. And presumably want to make the point that any individual licensed to provide any sort of legal services continues to be subject to all of those requirements, even if practicing through a sandbox entity.
Yeah, that's a good point. We haven't really been focusing on paraprofessionals in our discussions and those rules, but yeah, that would be absolutely as applicable.
Micah next, and then Toby.
Are we going to engage in any sort of what I would call a reconciliation process? So if the paraprofessional group says we're recommending 5.4 get modified and not apply, and we say no, it should govern if you're working as a legal professional unless you're in the sandbox or specifically included, how do we, are we going to do like the House of Representatives and the Senate does, where we come together at some point and figure this out, or we're just going to have different recommendations?
Let me provide a quick answer to that by saying we get the last word. They're supposed to finish their work within months, something like an hour, something like a year before we do. Someone in this meeting may have a more precise estimate of the timing, but generally speaking, we will know what their recommendation is and what the original moves to accept or not their recommendation have been before we have to finalize what we're doing.
Does that mean we have the final say on what they do?
No, we don't have the final say on anything. All we get to do is make a recommendation to the State Bar Board.
Okay.
So we don't get to, all we get to decide is what we are reporting. And so we will report out in full knowledge of what they have done on the subjects that we were asked to make recommendations on. We won't say whether we like or don't like what they're doing. That's not really our charge, but we will know what they have done before we finish, is the point I was trying to make.
So is the Board of Trustees responsible then if there's a conflict?
Well, I would take it one step further and say yes in the first instance, because the State Bar Board needs to decide whether or not to make recommendations to the Supreme Court and the state legislature. But my understanding is that the paraprofessional working group, as does our group, is going to be making recommendations that would take effect only on the action of these other entities. So at some level, the Supreme Court and the state legislature would be the ultimate reconcilers if there's a conflict in recommendations.
Thanks.
Toby.
Yeah, we have talked a lot about how the primary focus of the sandbox is 5.4 and some of the issues around that. I just want to make sure that this is not in any way limited, and that if the rule that somebody wants to deal with is an advertising rule that they want an exemption from, or the referrals, the solicitation rules, or sort of any of them. And in fact, it would include statutory exemptions as well, both in terms of UPL and the LRS statutes and other statutory exemptions. And if that's true, would assume the Supreme Court wouldn't be able to authorize that, but would have to go, the legislature would have to authorize the Supreme Court to make those exemptions.
So I think that's true and a good point. I think one difference between the way we do things in California and the way they do things in Utah, as I understand it, is because we have more attorney regulation by statute.
Right.
This is an issue that Utah doesn't squarely face. I also think, and I could be wrong about this, but it seems to me the legislature might not want to be told, please provide an all-purpose exemption authority for the Supreme Court. So we may need to come up with a list of statutory obligations that are waivable. So for example, we might have to decide, is the relatively new California Consumer Privacy Statute something that is waivable in the sandbox, or is that something that is not waivable in the sandbox? Obviously, the legislature will ultimately make that decision. But one of the things I think we ought to be thinking about is making a recommendation about which statutes are we asking the legislature to give the sandbox the authority to waive. Maybe we don't have to do the same thing for the Supreme Court. There's a more defined and targeted list of ethical responsibilities of lawyers that the Supreme Court directly oversees and can waive. But precisely because the Supreme Court can't waive statutes without being given permission, and the legislature is unlikely to say, sure, Supreme Court, waive any statutes for anybody you want. That's why I think we may need to be a little more systematic on the legislation front. Okay, I see a collection of hands waved. I'm not sure which are most current. Micah, do you have a point? You're unmuted, you do. Okay,
Yeah,
good.
that was a mistake, but of course I have more questions that have arisen since, but I won't ask them now.
Okay, and Kevin, are you still current or show?
Yes, I am.
Okay,
No, just to point that, well, I'm current as to this meeting right now. But anyway, just something that Micah mentioned earlier, that about these waiver of, and what Toby mentioned about waiving of statutes and the like. I think that if you look at 6125 of the Business and Professions Code, it says no person shall practice law in California unless the person is an active member of the state bar. And then it goes on 6126 and so forth. There's some reference to being otherwise authorized to practice law. So the extent to which any of the statutes need to be changed, we have to take a close look at it to see what language needs. But regardless of whether we decide that maybe a statute doesn't need to be changed, I think we probably still have to get the legislature on board as to what we're proposing to do, because when the statutes were originally passed and adopted, they were intended to do one thing. And I don't think we should necessarily be in the position to try to interpret them to allow something else that might not have been in the contemplation of the legislature when the statute was passed. And I just wanted to follow up that point. What is being done by the state bar? I know that Donna Hershkowitz, when I raised this issue last meeting or the meeting before, is the legislature being informed with what we're doing, and to what extent are they being informed, so that we suddenly find out that we finally agree on what we're going, the recommendations we want to make, and the legislature says, what's going on? I mean, I don't want to surprise the legislature. They're very possessive of their fingers in the pie dealing with the legal profession. And I don't think that our legislative representative has been able to attend any of our meetings so far. And it's a bit of a concern of mine, and I'd prefer them to be involved earlier rather than later.
thank you. Bridget, you have a question or comment?
Yes, Kevin, I was going to say the same thing and asking the question generally and wondering from a process standpoint. I don't think we really had something with ADLs. I know we had representatives, but could we invite like the chairs of the judiciary committees to speak with us, or could we have some kind of roundtable or something with them to understand where they're coming from on these issues? I do think it's really, really important that we do involve the legislature somehow. And it is unfortunate that I don't think we do have representatives from either house that have been in our meetings right now.
So let me jump in and say, I don't think the answer to this question has changed since Donna shared it last time, which is that she is informally, but directly able to talk to representatives of the legislative chamber. We've offered them the opportunity, but can't make them accept it, to have representatives participate with us in all of our discussions. We fully understand that we need to have their input and their buy-off before we are finished. But we generally also understand that we don't want to go and say, well, we're thinking about all these issues. What do you have to say? We want to go and say, here's what we have done. Here's what we are thinking. Now, what do you say? So I would encourage, I hear both of you. I think those are a very important point, but let's table it until we have something to say to them for them to react to.
I
And
would just say, I
want everybody involved in trying to make that happen. Yes.
I agree with that we need to be very strategic about it. I would just offer that I think it should be at some kind of midway point, so where it's not going to appear that we've already decided, like we actually maybe are seeking some input and some guidance as we are developing our recommendations.
Good point, and thank you. Micah, do you have a question or a comment? You're on mute.
Just a comment, as someone who's worked very closely with Assemblyman Stone and Senator Umberg, I don't believe they are fully aware of what's going on and what we're doing. And I think a midway point is a good idea, but I actually think we should be providing them with information now, because there are interpretations of the justice gap, there are interpretations of what our charter is, and I think that we could get to a point, and this is something that in 2019, when I talked to I think it was the whole board of trustees, I suggested that the groups reach out to political organizations to get a to have a check-in and take the temperatures of the people who are going to ultimately have the final say. And I think that we're doing the work of this committee and the paraprofessionals committee a disservice by going at the end or even halfway through to ask for buy-in, because I don't think it'll be there. That's my, just knowing what goes on in the building and the issues with the dues bills that the state bar has had in the past. I really think that there will be some discomfort or unhappiness about how much time and effort and money was spent even getting to the midway point when there's no political appetite. That's the worst case scenario for what is being suggested. So I think that those relationships, people who have relationships and the ability to have dialogue, we should be taking advantage of that now, or it could be very difficult at the end.
Okay, let me ask the following then. Anybody who has a relationship with, and Micah has just identified herself, sorry, Micah, but anybody else who has a relationship with either Assemblymember Stone or Senator Umberg, or if you think there's somebody else who would be who serves on one of the committees or otherwise useful, who you have a relationship and think you could assist us in getting their attention in a way that staff channels maybe don't, that would be useful. I'm not going to ask you to publicly identify yourselves here and now, but I would ask you to shoot me an email if you would be so kind and let me know who it is and whether I can call you and at what number to discuss further. And we'll do a little offline brainstorming for those folks who are most directly in a position to help us figure out what we might do. So we won't do anything further on this subject right now, but except that that's homework for anybody who has something that they would like to weigh into my email box on, so that I can follow up directly with you. Okay, which brings us, I think, back to Mary, you had one issue and we've given it a fulsome discussion. Do you want to move on to a next issue?
Yes, I think I would go back to Jim, and Jim, what would be helpful to get from the committee in terms of, trying to move forward on your memo?
It would be helpful to get a reaction to the 3 harms that we've identified that we're trying to address in our sandbox regulation. The 3 specified are close to, but a little bit different from the harms that were identified in the ADLS report and the Utah Office Manual. I would point out Crispin Passmore, in the memo that he circulated yesterday, identifies a background harm, which is the harm of getting no service at all. I don't think that's a harm that fits on our list, because almost by definition, an applicant for the sandbox is trying to address that harm and to provide service. I think his point is very relevant to what the appropriate criterion for assessing the risk of harm is, because anything that reduces the risk that people who need help will get no help should be factored into our evaluation of sandbox proposals. But the 3 bullets here on the page in front of you are the harms that we identified that we should be trying to protect against or mitigate in sandbox regulation.
If I could just add, I think there was the tweak, which I thought was helpful, that really is an improvement off of what it says in Utah, is in the second bullet. That talks about failing to exercise legal rights through bad advice or incomplete information. And the concept that I think was brought into that is this idea that some provider could propose sort of half of the solution and be promoting that without really giving people what would be perceived by the regulator as a sufficiently complete treatment of the problem. The example was you could give people advice about how to write a lease, but not make it clear to them who needed to be parties to the lease in a multiple tenant situation. And that would be sort of a perfectly good lease, but not really the full story for people. So that wording about incomplete information, I think, is an improvement over the way things are worded in our Utah documentation.
Becky has a comment, and then Tom.
So I like these a lot. I just wanted to raise a couple of things that the way they're worded made me think. So I like the change, the modification to the second one. I think in its implementation, we're going to want to think about the scope of service. So I might design a scope of service where the design of the whole thing is going to give incomplete information in some circumstances. And so how would I'm only going to talk to you about your landlord-tenant problem. I'm not going to deal with your family issues, because what I do is help people who are being evicted file answer forms and connect to rent assistance, right? So sort of thinking about how to implement that in a limited scope context, I think, is an important question. The other thing that I maybe would push back on a little bit is worrying about a consumer paying an unnecessary or inappropriate amount. And the reason I'm worried, I'm pushing back a little, is not because I don't think that that's a real concern, but how would we have the data to assess that empirically, given that we don't know what the cost of conventional legal services really is? We only know what people pay. So sort of I guess it's another issue of implementation there. How would we know it was an unnecessary cost or an inappropriate cost?
So Becky, how would you change on the scope piece? How would you change this language?
On the third one?
No, on the scope of service piece, that your first point.
Within the scope of service that the consumer signed on for, some language like that. You will all be better at crafting that language than I will. But
it sounds like what Becky is proposing is something analogous to a limited scope representation that's permissible under Model Rule 1.2.
Yeah, I mean, this is Mary. I think the issue is only in terms of, how we define incomplete information for purpose of this harm. We mean incomplete within the limited scope that the consumer has agreed to.
Right. So really, it's a modifier of second bullet. The consumer fails to exercise legal rights through bad advice or incomplete information within the scope of the requested services. Something like that.
Yeah.
Okay, Tom, did you have a question or comment?
Just a question that this may be just editorial goofiness, but both 1 and 2 seem to be mechanisms that lead to harm. So I, as a consumer, might be harmed because I, in bullet 1A, received inaccurate or inappropriate legal services. But the harm itself is, I was kicked out of my house, or my will didn't work and bad things happened. I assume that's kind of what we really have in mind, but these are the mechanisms as opposed to the actual harms, it seems to me.
So the consumer could be harmed because they receive.
Right, exactly. I mean, that seems like more what you have in mind, but.
I guess the question becomes, is that an analytic point that's interesting but doesn't require revision, or are you proposing a revision of some sort? And while you're thinking about that, let's hear Marta's question or comment.
Well, my concern or my comment, or a combination of those, is related to a person, for example, that comes in having, the requested service, quote unquote, may be related to a landlord-tenant issue, but as the evaluation or the discussion ensues with that particular individual, there may be bankruptcy issues that could arise. There could be, maybe the home was riddled with mold or other terrible problems, or which could require medical care or attention, or a reference to some other organization that could help in that regard. So limiting it to within the scope of requested services might actually be an inappropriate limitation, because I think a lot of people that come in for legal services may not understand exactly what areas of help they may be eligible for based upon the stated problem. So that's a kind of comment and something to tweak or think about.
Yeah.
And as long as I'm rambling, the third point, I am concerned, and I like the fact that a consumer purchases unnecessary or inappropriate legal services, because I think that is a potential harm that we should be mindful of, considering the history in California of people being unfortunately ripped off by people in immigration that were seeking help with immigration matters. And also what I'm concerned about is subscription legal services, where somebody is getting, billed, an amount every month and is not really paying attention to that. And they're never really taking advantage of the legal services that are being charged to their credit card. And they are now having bigger issues with respect to paying high interest on a revolving credit debt that they cannot afford to pay. So I think there is merit to point 3.
So Tom, I promised we'd come back to you if you want to speak next.
Sure. I think this is more Scrivener, but I think about it thing to the committee would be perhaps in the prefatory text, insert arising from. That would solve the first bullet and the second bullet. The third bullet is its own sort of harm. So you might want to consider striking the consumer purchase it and insert the provision of unnecessary or inappropriate legal service. But I could live without those changes being made, but it just bothers me in terms of the English of it, but you guys feel.
So those are helpful and concrete suggestions. I'll let our Jim and company take them up rather than trying to finalize the text collectively. Let's see, David Engstrom and then Bridget.
So this swings us all the way back to the very beginning of the segment, and also I think what Marta just said, I think it connects to her comment as well, which is, I guess I wonder whether we should be so quick to bracket a failure to provide a service. It does seem like you could imagine a provider that is operating on a subscription basis and they're operating at scale, and you can imagine that they would fail to provide any service at all. And it is indeed covered by the third bullet point, I suppose. That would be paying an unnecessary or inappropriate amount. I guess it could also be failing to exercise legal rights through incomplete information, but those are only a roundabout way of getting to the problem of a failure to provide a service. And so I wonder if a fourth bullet wouldn't be in order that brings back in that concern rather than bracketing it.
A fourth bullet, or perhaps just eliminating the text that's in blue? Would eliminating the text that's in blue address your concern also? And if not, perhaps you could work on what that fourth bullet would be and share it with us when we come back to you. And I'll call on Bridget and then Toby.
Yeah, mine is quick too, just kind of circling back. I was just looking at my notes from Jillian's presentation this morning, and maybe she can send us her PowerPoint, which I think would be helpful. But just looking at she was talking about the risks more in terms of larger concepts. And I think what we have written here is much more specific, which is maybe better. I'm just throwing out what I had written down for her identification of the risks and just food for thought about whether we've encompassed them all. So she has legal error, which I think we have, loss of legal rights, incorrect or bad advice. But the ones that I'm not sure that we have actually covered are fraud, theft, and abuse of trust or conflict of interest. And I think maybe they are underlying in these other 3 bullet points, but I just wanted to throw it out there to make sure we're really covering it.
Good.
So fraud, theft, and abuse of trust would be a potential additional point. Toby, you're on. No, I'm sorry, Toby, you're on mute.
Sorry. My concern was raised by the blue language that was added to the second bullet. I'm thinking in terms of, for lawyers at least, they can limit the scope of their services, but if they do so, they can't, there's a famous case, the name of which escapes me, that says that the workers' comp lawyer that takes on a workers' comp case and does a wonderful job, but doesn't advise the client that he's not handling a third-party claim case, that's a malpractice by the workers' comp lawyer. And
The case is Nichols against Keller.
yeah, thanks, Kevin. And what I don't want us to be in a position where, unless we're consciously doing it, saying that other non-lawyer providers don't have to do that, don't have to tell people that there may be other issues you should know about that you may be giving up by not pursuing them either through me or through someone else.
Can I just, this is Mary, I just want to say something about this, and all this is, very helpful and useful. We're not trying to devise every single possible sort of rule, guideline, enforcement mechanism here. We're really just trying to identify the potential harms around which, we are then going to, the purpose of this immediate process. And these 3 basic harms were basically taken, from ADLs with a little bit of combination with Utah. So certainly room to improve them as we're doing. but just to, I guess, reassure people that, for example, and that's a really good concern, Toby, if you're going to, when you limit services, what kind of disclosure do you have to make to clients to, about the limitation of those services? Really good point. Probably not something that necessarily has to fit within what we are doing right now.
As long as we don't forget it as we go through further.
Yep, absolutely.
Tom, do you have a question or comment?
No, sorry.
Okay.
Get my hand in here.
David, I promised we would come back to you if you want to be proposing an additional bullet, or if you want to join the folks who are saying, let's get rid of the blue text in the second bullet.
Oh, this is gonna muddy things further. I guess my objection to the second bullet is incomplete information. I stumble over that every time I read it, and it suggests that some information has been provided, but not enough. And I guess we're looking at, a problem of maybe no information was provided, no services were provided. The client was ignored, though was paying for a subscription. So I guess I object less to the within the scope of the requested services. I think that makes sense. I stumble on incomplete information.
I will tell you that it was my recollection is it was a substitute for the word ignorance, which was there previously. And we thought this was perhaps a better way of conveying that a consumer was acting without enough information, not being an ignorant person.
So for David's point, would the new bullet point that's thrown in down here and not really fleshed out yet, it maybe doesn't have to be, but the fraud, theft, and abuse of trust, would that encompass the issue that you're raising?
Sure, I think it could. I just to adopt Tom's comment a minute ago, these might be Scrivener concerns at this point. I mean, based on what you just said, Mary, where we're not trying to capture the universe of everything. This is not trying to create a watertight set of regulations. Rather, it's supposed to, spotlight some types of harms that we want to orient our thinking around. So maybe, maybe I'll stand down on that if we've already been through incomplete information and changed it once from some other term.
But it seems to me that you're identifying something that is certainly, and Martha too, that a possible harm, which is, that someone doesn't get what they paid for, for whatever reason, which could include, no services. And it seems to me that might fit within that new fraud, theft, and abuse of trust.
Sure, I think it does. I think that fourth bullet point is nicely capacious in that regard. I think it can cover a lot of things. And so maybe that's the perfect way to tie all of this up.
Great.
There is a whole issue that the fourth bullet point raises about how conflicts works for our non-lawyer service providers. But I don't think we have to answer that question in order to say that we like flagging it as a potential risk here. Okay, there are two more comments, one from Randy, one from Eric on this subject. Randy.
I just wanted to note that since the word incomplete is highlighted on the screen right now, that I do think it's a juxtaposition between the term before the disjunctive. So it's really a contrast between bad advice versus incomplete information. And I think it goes directly to what Toby was mentioning and what Kevin crystallized for us by the reference to the Nichols case. The Nichols case was not a problem with the lawyer's advice. It was a problem that they didn't give notice and information about something that was outside the scope of the requested services. And so I think there is value to referring to incomplete information as being a type of harm.
And given the references to the Nichols case and the comments that a number of you have made, is there any objection to our striking this language within the scope of the requested services? I'm not hearing it yet. Eric, did you still have a comment or do we move straight to Becky?
This was just a very quick point. One of the things that came up in the discussion of what the bar was sanctioning, both unauthorized practice of law and lawyers, was actually just not delivering the service at all. And I did wonder if we wanted to add that, because it's, if I simply don't provide the service, and I'm in a non-legal situation, there are remedies for that. But we're saying there's a heightened risk because I would then lose legal rights. And so I do wonder if just incomplete, or if we just need one more word that says not doing it at all, because that sounds like that's actually a bigger risk than I guess I thought it would be. I take
Might
your
be
money.
incorporated by fraud, theft, and abuse of trust.
Yeah, that's fair. Actually, that's true, because we now have that. Okay, withdrawn.
Becky,
So I want to make sure I understand, setting aside the language, the substance of the conversation around the second bullet point. So is the sense of the group that whatever the type of provider, it is subject to the same kind of malpractice considerations that a lawyer would be? So that if you're coming to me for help with your eviction and I don't do bankruptcy, and I don't tell you maybe you should get a bankruptcy, I then have harmed you? Just sort of, can somebody give me an example of a non-lawyer provider so I can understand the substance of what this would mean?
so maybe someone can give you a quick Nichols case reprise. I would.
That's of a lawyer, though.
Ah, I see, of a
Yeah.
non-lawyer provider. Got it. Well, one of the questions I had for Professor Hatfield that we didn't get to that I wanted to email her about is that I noticed that her concept of risk-based regulation included both consumer law and malpractice law as potential enforcement mechanisms. And I don't know whether she has in mind that there would be any malpractice type regulation against people providing legal services who were not lawyers. If so, it would be a whole new area of the law. But I'm not sure that, well, let's go, let's see if anyone wants to supply an answer to those questions. I see hands raised first by Toby, then by Kevin.
One that occurs to me is somebody comes in for help with an eviction defense and is given an answer and a response on the eviction, but no mention that the eviction was in fact based on an underlying foreclosure, and there may be defenses to the foreclosure and affirmative litigation that could be brought to that. The client is harmed by the fact that they may get evicted because there may not be a defense, whereas if they knew about the foreclosure and could get some help with that, they might in fact not have to leave the house.
Or another example could be failure to advise about the statute of limitations, right?
Yeah.
Kevin.
Yeah, the thing I was just going to raise, and I'd raise this point with the paraprofessional working group about the importance of educating the paraprofessionals, and they're going to be educated, but that they have to know about areas other than the specific area where they're going to be authorized to practice. Because my understanding in the paraprofessionals, the proposal is it's only going to be in limited areas where they're going to be able to practice, appear in court and so forth. But my concern was the Nichols against Keller concern. Would they be able, would they have the knowledge to advise the client who came to them, okay, I can do this for you, but you also have to take in consideration this, and the only one who can provide you with that help would be a lawyer. So to jump back to what the concern that Becky raised, I think that maybe if we're going to authorize non-lawyers within the sandbox to provide or recommend that they be authorized to provide, certain types of legal services, not the full panoply of services that lawyers do, then perhaps they should be required to be sufficiently familiar with related areas of law so that they can provide the necessary information to clients so the clients can protect their rights.
Thank you. Before we move to other questions or comments, I have a question for Mary in her capacity as SAGE co-chair. We had planned to have the Office of the General Counsel presentation happen now in what would be the next 20 minutes. Do you want to move to that and interrupt this discussion and then return to this discussion for a bit after the OGC presentation?
Sure, I think that's fine. I also am, recognizing the fact that we interrupted Scope earlier and we need to get back to them. So it's, I think having Brady's presentation, based on what I understand of it, probably is a good idea. And Brady, you can correct me, but from what you said earlier, I'm not sure it's going to take too long, but it will be a good update for everybody.
And I did promise Scope that we would return the discussion to their subject by 4 o'clock, but that does give us some time after Brady's discussion to come back either to the harm discussion we've been having or to whatever the SAGE committee thinks would be the most useful input that this larger group can give.
Can I go ahead and share the screen now, Justice Tucker?
Please do. Thank you.
Great.
Brady Jawar from the Office of General Counsel. I think you all know him. And yes, please go ahead and take over the screen and go with it.
Have it open. Just 1 second. Bear with me. Apologies.
And because we're squeezing the time for your presentation and you've let us know that some of the things are preliminary, if you want to go particularly quickly over the preliminary subjects and spend more of your time on the things where you think you're closer to finished, that will probably be a good use of the committee's time, since my understanding is you're going to come back to the SAGE subcommittee with a follow-on briefing when your work is finished.
Sure. There we go. Can everybody see the PowerPoint now?
Yes.
Great. Hey, everybody. So at the last meeting, your discussion led to the identification of some legal issues that might come up with the three structures for the sandbox regulation entity that are under consideration, those being either an independent nonprofit, a sister agency to the state bar, for lack of a better term, but a separate agency under the Supreme Court, or an office or department entity within the Judicial Council. So we've sort of boiled those down, crystallized those into 7 areas of inquiry, which are antitrust, conflict of interest, whether any particular structure poses a conflict of interest for the court, doctrine of unlawful delegation, ability to contract for services from state entities, funding from private sources, Government Claims Act immunities, and Article 7, Section 9 of the California Constitution. And won't test your memory, I'll remind you what that is at the end. The 2 areas for concern, and I'll try and go through this quickly because this is still where our research is and discussion is ongoing, involves 2 potentially countervailing concerns. First is antitrust issues, and the second is conflicts of interest for the court. As I think many of you are aware, the basic parameters of the antitrust concerns, but those concerns would weigh in favor of closer supervision by the Supreme Court or potentially another government entity like the Judicial Council itself. The sandbox, by deciding who gets to play and who doesn't, by necessity would be making anti-competitive or arguably anti-competitive decisions. And therefore, there are some antitrust concerns. These are pretty much eliminated if the decisions of the ultimate decisions of the sandbox regulation entity can be considered state action. And that test is met if the sandbox entity, for instance, like the state bar, were to make just recommendations to the court about who's in, who's out, who gets kicked out, those sorts of decisions. Then the decision is ultimately that of the court. The entity is just an advisor, and any resulting anti-competitive decisions or state action, and therefore insulated from antitrust challenge. If we have a model where the sandbox acts at its own, its actions may still be protected as state action, Again, the action needs to be subject to active state supervision, and the action must be undertaken pursuant to clearly articulated rules and policies. So really in practice, both options for escaping antitrust inquiry do require significant involvement and oversight by the Supreme Court or another part of the government that doesn't constitute market participants, like the board of our entity, comprising volunteers who are attorneys or technologists, presumably would. So we are hard at work trying to figure out the exact contours of these restrictions and how to operationalize those in advice for you. The conflicting concern was raised at the last meeting by Supreme Court staff and some members of the working group as being potential conflicts of interest for the court if it gets too involved in the sandbox decisions. Those potential conflicts under consideration, one raised by members of the working group, was in the event that the sandbox entity accepts private funding, concerned that the court, or actually whatever decision maker is involved, might have some conflicts as a result of accepting funding from either an industry group or an actual participant in the sandbox, that it would make it difficult for the court or whatever decision maker to fairly hear disputes regarding the source of the funding. The second area of potential conflict for the court was raised by court staff, and that is that in the event the court is the ultimate decider of who gets to participate in the sandbox, who's in, who's out, who gets disciplined, concerned that the court would not be able to hear cases concerning the sandbox entrance. So say Microsoft was one of the sandbox participants, the court, by making that decision, could be seen to have a vested interest in Microsoft and its success. And then would that or would not that not cause a conflict for the entire court in other litigation that reaches the court involving Microsoft? In these two areas, we've found no authority right on point that says, yes, this would be a conflict, this would cause a problem for the court. But on the flip side, we haven't been able to disprove it yet. So that's sort of what we're working on right now. And hopefully we will have a resolution to advise you on at the next meeting. The other areas are a little bit simpler for the most part, more open and shut. First, the doctrine of unlawful delegation. That would necessitate final review of actions by an independent nonprofit. So if we go that way, basically, most of the case law here involves delegation of the legislative function, because generally regulation is a legislative function, and the legislature might delegate that to agencies. Doesn't happen so often in the judiciary for obvious reasons, but this is an area where the judiciary has ultimate responsibility for regulation, and so we would apply some of the same principles in figuring out whether and how much can be delegated. And basically the answer here is that while it would be permissible to have a nonprofit act in an advisory capacity, again, the judiciary can't delegate all decision-making to an independent nonprofit. It would have to have oversight and make the final decision on regulations itself. The other areas of inquiry are even more open and shut. First, the ability to contract for services from state agencies. There's no legal provision on doing so. There are examples that we've found of that happening. For instance, close to home, when the California Lawyers Association was spun off from the state bar, the legislation that accomplished that made allowance for leasing of employees for a period. On the other hand, so there's no legal prohibition we have to worry about, but it is probably more of a political operational question in terms of whether any particular state agency would have the capacity to lend employees the willingness to do so, but there's not a legal impediment there. Second, funding from private sources. Again, there's no blanket prohibition that would say, no, we can't do this. And there are many examples, public-private partnerships, private donations to public university systems. But accepting such funding might create the appearances of conflicts of interest. And that's something that should be considered in deciding whether to pursue that as a source of funding versus user fees or general funds. Government Claims Act immunities. I should backtrack. We're still working on this. We haven't, let's just put it this way. It is likely that without further legislation, if we housed the Sandbox regulatory entity in an independent nonprofit, that likely would not be seen as a government entity for obvious reasons, and therefore would not be subject to and protected by the various Government Claims Act immunities that, for instance, the State Bar has when it gets sued. So that's probably not a deal breaker. And of course, if the legislature were inclined, it could extend immunities, but might be something to be considered just in deciding the pros and cons of the independent nonprofit route. That there are some benefits to structuring an entity either within or as a new public entity. And finally, we took a look, this came up in discussion at the last full working group meeting, at Article 6, Section 9 of the California Constitution. And that section provides the State Bar of California is a public corporation. Every person admitted and licensed to practice law in the state is and shall be a member of the State Bar, except while holding office as a judge of a court of record, excuse me. And if you took that very literally and broadly, every person admitted and licensed to practice law in the state is and shall be a member of the State Bar. Well, if we are licensing entities to provide limited practice of law services in the Sandbox, then one could read this as saying that entity has to be a member, is a person and has to be a member of the State Bar. There's not a lot of law on this issue. It was passed as part of a big package of basically constitutionalizing various structures of the government in the 1960s. The ballot materials did not even mention this provision. They sort of just summarized makes changes to the structure of or formalizes the structure of the judiciary. However, there has been one attorney general opinion on this constitutional provision, and that looked at whether multi-jurisdictional practitioners who under the rules of court are permitted to engage in certain practices of law activities in the state without being a member of the State Bar, whether that is a violation. And the attorney general opinion made quick work of that, said, look, this constitutional provision, really all it's saying is that if you're a lawyer, a full-on lawyer in California, then you're a member of the State Bar. Nothing more, nothing less. And that is consistent with the various exceptions. People who are admitted pro hoc vice in the state are licensed to practice law on a limited basis, but they're not required to be a member of the California Constitution. So I think we discussed this with Justice Tucker a bit early on, and I think we're all comfortable that there's not a constitutional bar on housing this entity outside of the State Bar. So those are the areas we've looked at. A few of them we are still deep in, and we will look forward to providing some formal advice to the SAGE committee. And if you have any questions or thoughts on any of that, be happy to look into it.
Thank you, Brady. I really appreciate that succinct report on some important issues. Are there questions? I see Mary has a hand raised, but that may be a legacy indicator.
That's legacy.
Do you have questions for Brady about his presentation? Becky.
So this is going to be an annoying question from a total layperson from a place of deep ignorance. But thinking about this issue of, you don't want the Supreme Court to be conflicted out of performing its role as the Supreme Court in the state. Like, I get that that's a challenging issue. But here's my layperson question. Does it make any difference in terms of creating that conflict, how the approvals are structured. So right now in Utah, the Supreme Court writes a new order for every entity that is specific to that entity, which is a very bespoke and completely non-scalable model. But you could imagine a different model where the court considers models. It says, okay, you can have 50% non-lawyer ownership and this kind of technology, and anybody who applies to that, we think that's fine. We accept that. Would that resolve this conflict issue or help with it or change it in any way?
You know, that's a very good question. And my sense when I heard this posed was that the idea that there could be a conflict was related to how much discretion the court was exercising in making these individual determinations. So that's a very good question and something, you know, that we'll look at. And the answer might be that there is you know, no conflict, but so either your suggestion of changing the model will resolve the conflict, or perhaps that won't even be necessary. But that's a good point for looking at. Would you agree that it's sort of about removing the discretion from the individual, you know, entity toward making decisions about the parameters and which parameters will apply?
I probably don't know enough to answer your question as you posed it, but I guess the way I'm thinking about it is, rather than the court saying it's okay for LegalZoom to do X, it says it's okay for everyone to do X.
Gotcha.
And then what the office does is decide whether LegalZoom does X, whether law whatever does X, so that the court is still the regulator, the ultimate regulator, but it's not making the decision about specific entities.
Okay. I mean, I think ultimately you'd want review even of the final decision, but we'll give that some thought.
Thank you. Micah has a question or comment, and then David. Okay, Micah, you're on mute. Let's for right now, let's focus on questions that are specifically on this point about Supreme Court conflicts. And I see that our Supreme Court staff liaison has his hand raised. So I'm actually going to take him out of turn and ask Neil to speak.
Yeah, you don't have to do that.
I'm gonna anyhow.
Yeah, it just a short thing I wanted to say really quickly is, and it just sort of jumped into my mind right now, is the idea of maybe special masters reviewing decisions made by the regulatory sandbox. So in other words, what the court could do is say, put together a panel of 3 special masters, judges and justices from the courts of appeal and the superior courts to sort of do the judicial review of any of this. That's throwing that out on the table as an idea.
Okay.
That's a very helpful suggestion. Thank you. Are all the hands raised on the subject of Supreme Court conflicts? If so, let's have Micah and then David, I think is what I said previously.
I just would like kind of a better, more fulsome explanation of the constitutional issues. I didn't completely understand why the conclusion was that there didn't appear to be any conflicts under the structures that are under consideration.
Can I ask you to clarify that question, because you mentioned the constitutional issues? Are you talking about the Article 6, Section 9
Yes.
bar requirement?
Yes.
Okay, I'm going to ask that we get that question answered by having Brady circulate in the chat a link to the Attorney General's opinion, or if he's not able to do that on the spot, to send it around by email afterwards, because I think that's a very important question and I don't want to shortchange it by just trying to get an off-the-cuff answer. But the Attorney General's opinion of which he spoke, I think is a helpful.
And I'll do both that and just because I said these are resolved, I'll still address them in a written memo that will go out to Sage and then the full committee.
Great, thank you.
Perfect. David.
I guess I just wanted to make the brief point based on something Brady said right at the end a moment ago. I'm not sure that discretion is the difference between the two scenarios. I think there's discretion in each case, but where the court is operating in bulk and I guess trading in parameters, as you put it, Brady, like there the court is engaged in something that feels like rulemaking to me, not adjudication. And of course, that ultimately has constitutional implications because due process does not attach to rulemaking. It only attaches to adjudication. So if I was attacking this, and it sounds like you have some case law research still to do, I would think in terms of the distinction between rulemaking and adjudication, and less in terms of whether there's discretion being exercised. I think there's discretion being exercised in either scenario.
Okay, thank you. Becky and then Eric.
That's just bad management on my part. I have nothing to say.
So this, I guess, is a kind of a question for John, and then depending on his answer for Brady. John, in Utah, is there? I guess I was looking over the applications to the Utah Sandbox, and they're very specific. And I kind of like Becky's position that says if you could judge these as a business model. But I just having looked at those, it seems hard. I guess my question is, in Utah, is there kind of, I don't have a better word for this, but a common law that says if we sort of approve this business model once, and someone came in with a similar business model, they would get a similar treatment?
That's evolving. You know, as we get the next one that looks like the last one, it starts to become clear that there actually is probably some norms and some standards that can be articulated.
And then my follow-up standard, but is that a way to get to what Becky's talking about with that they're really kind of making rules sort of more generally rather than something that's very entity specific? Because I just think it would be hard to make that decision at the outset, the first time you saw a business model. But I would also think it would be very hard to say, well, we approve LegalZoom, but you know, other entity, you can't do exactly the same thing under the same parameters.
Okay, Bridget has a question or comment.
Just very quickly, I was just going to say I really like Neil's suggestion. I realize you're not saying this is like approved or anything, Neil, but I think having a special master set aside to deal with these issues would really help with a lot of it, because David is really right about the distinction between rulemaking and adjudication. And this seems to be maybe more adjudication if you're looking at it on a case-by-case basis. But anyway, I just wanted to second that, as I think that could be a great way to, and more efficient way to deal with this.
Kevin has a question or comment.
I just want to throw out something because I don't see the conflict at all, even if the Supreme Court admits a person to the sandbox and exercise discretion in doing it. It just seems that they are approving a particular model. And then when it's going to be adjudicated, because the person has departed from that model that they proposed presenting to people. By analogy, and I'm sure any number of people will say it's a poor analogy, they usually are when I come up with it, but there's the famous Silverton case where a member of the state bar was disbarred. The Supreme Court readmitted Mr. Silverton, exercising its discretion, and then they disbarred him a second time. So if we're saying that their adjudication, exercising their discretion, is going to prevent them from subsequently dealing with an issue where there's been a subsequent violation, then the Supreme Court shouldn't have been able to disbar Mr. Silverton for a second time. So I just don't see it. It just doesn't seem to be that big a concern for me. I'm not sure that we need special masters. Perhaps Brady's further research will demonstrate that, yes, we do. But right now, I don't see where the...
I'm also looking in, the Supreme Court, for instance, the state bar is sued, and the Supreme Court hears those cases. So I'm looking at whether there's been, any challenges to that and why that was resolved also.
Neil.
So just to frame it, Kevin, I know I see your point, but to frame it in sort of a different light, what's going on here is essentially, someone could say that by admitting Microsoft into the sandbox or whatever company we're talking about as an example, we're letting this corporation or player in the sandbox in under relaxed rules or practice, right? And so that's the appearance that one could argue that we're allowing this group or this entity to come in under relaxed rules where everybody else has to play by a different set of rules. So that's the concern, I think.
And perhaps relatedly, if Microsoft then gets sued for, let's call it legal malpractice or consumer fraud for having failed to disclose that they weren't lawyers or whatever, then their defense might be, well, we were approved by the Supreme Court to do X, Y, and Z, and the Supreme Court would not want to have to recuse themselves in judging that specific case. Andrew.
I don't want to belabor the point, but my understanding of the conflict was in the nonprofit setting where an organization that's the regulator is a separate nonprofit organization which needs to solicit donations. And one of the donators then comes before the Supreme Court in an unrelated case. And the Supreme Court is relying on that donator to set up this regulatory structure. I thought, I might be misremembering the conversation. I think it was from 2 meetings ago. I thought that was the conflict that we were looking at, because I agree with Kevin. Admitting someone into, I mean, there's all kinds of analogies we could come up with. I don't think admitting someone to participate in the market would preclude the Supreme Court from later adjudicating that person. I don't see how that would be a problem. I'm happy to be corrected should the research lead us that way. But all that to say, I'm trying to reframe the conflict. I thought it had to do with a monetary donation with one of the regulatory structures we were considering, which seemed somewhat problematic for other reasons, but this was one of those reasons.
I'm going to thank you for reminding us of that aspect of the conflict and say that I think that there were 2 different kinds of conflict, the one you just mentioned and the one we've been discussing more of, so that as we go forward with receiving advice, we would want to consider both kinds of conflict. And obviously the Supreme Court admitting decision conflict would exist regardless of which kind of, would exist for multiple different kinds of sandbox entity structures. Toby, you have a question or comment? But you're on mute.
Sorry. The one real quick one, and that is that the clearest analogy to me is that the Supreme Court admits every lawyer makes a decision to authorize the lawyer to practice law, and then hears cases involving that lawyer and against that lawyer, and doesn't seem to create a conflict there. The other thing I wanted to raise was that we've been talking about, back to it in my mind now, yeah, let it go. It's gone. It's there somewhere, but I'll think of it.
So Toby, I mean, that's a very good point, but there is a difference. The difference,
of course.
Yeah, the difference being is that we delegate to the state bar. The court delegates to the state bar the analysis of whether somebody should be admitted, right? Yeah. And then the state bar then essentially gives us a list of folks that
I know
the state bar says should be admitted. So there's no real precise individualized determination being done for each applicant, not in the way that I would see in terms of a sandbox applicant trying to enter.
Well, I guess that brings in my other question, and that is how detailed the Supreme Court will look at each individual application. If it's just the model, that's one thing. But if they're also looking at the entire recommendation, including the makeup of the board and the character and fitness issues and all of those kind of things, then it's much more particularized. And just defining the model wouldn't be enough. We don't want to, I think, say, if LegalZoom has this model and it's approved, then anybody with that model can come in and do it.
Yeah.
That undercuts all the other stuff we've been talking about.
And by the way, the example of the disbarred attorney and then readmitting that attorney, the reason why you don't see conflicts there necessarily arise is because the disbarred attorney can't practice. So, so the conflict issue right there is unlikely to happen. And that's not to say that if the court does eventually decide to readmit the attorney, that somebody else on the other side who's the opposition to this attorney in court could try to raise some sort of conflict issue based on the court's prior determinations. But I'm just saying that why we don't see this issue actually arise in that particular context.
Would still be a similar model to Utah. Someone would be making the recommendation to the Supreme Court. I understand the California Supreme Court, and I understand we're not near fleshing this out in detail, but there's no conflict issue concern in Utah. And that's not to say that they haven't looked at it, but all that to say, I guess I should just defer what Justice Tucker said before. We should look at this more carefully. My basic understanding is I would like to see a persuasive situation in which a conflict exists in a similar or analogous situation.
Well, John could correct me on this, but I think maybe the best way to characterize that is that the conflict hasn't arisen yet. Maybe.
All right. I think there are no outstanding hands raised. I'm trusting Toby, yours is a legacy. So I'm going to ask both Jim and Mary if they are ready to move us to a next topic, one or the other of you.
Yeah, and I think John's back too, and he and I have been trying to chat on the side to move this forward. And so, Jim, I guess I would first turn it over to you and see if there's anything more specifically that you would like to get from the group. And then if not, then we might go on to another kind of question to get the group's sense.
I don't have anything further that wouldn't be quite time consuming, so no.
Okay. John, do you want to ask the other sort of general question for feedback?
Sure. So this is this ties back to Professor Hadfield's talk a bit this morning. Was that this morning, this afternoon? I'm losing track. But in any event, it's this concept that the sandbox regulator probably isn't in a position to regulate individual actors, and instead is going to need to regulate an entity. And that's just the concept, right? We talked earlier about the idea that the attorney discipline rules, stay in force and effect for the attorney. And I guess other legal professionals who participate have their own ethical constraints. And by the way, if there were an accountant who was part of one of these entities, that accountant would have, a whole different regulatory regime for their work as an accountant, I assume. So the question really is, from the standpoint of the sandbox regulator, what is the subject of the regulation? And I think our working concept, and this is really the question to put out there, is that it's the entity. And the sandbox regulator is going to need to have the authority to suspend that entity, or at least recommend suspension of that entity, maybe revoke its privileges to operate, possibly be able to assess fines, but all of that would be directed towards the entity. The only other concept I guess I would raise around that I heard from Professor Hadfield for the first in my head for the first time this morning was, well, the sandbox regulator is looking at services as opposed to individual providers. But even there, I don't know that the sandbox regulator can direct its regulation towards the service. It really needs to be regulated towards the entity, at least as far as we see it. And then if that's a concept, just to be clear, that the working group, we seem to have consensus about, then I think what Mary and I would have in mind is that our subcommittee would need to go back and kind of articulate, what does that mean? What does that mean for the sandbox regulator to need to be focused on the entity as the subject of the regulation? So that's the subject. I'd throw it up for questions or comments from anybody.
Tom has a question or comment, but is on
A
mute.
rookie mistake here, sorry. I think I've got a question about that. So I'm not sure exactly what that means, John. I mean, I can imagine, say we've got a specialized firm that's going to offer landlord tenant services to tenants, and they help them with, you know, evictions and that sort of business. I think that, at least from my perspective, the regulator would want to look at the quality of that service. You know, you gave bad advice to Mrs. Jones and she got booted out of her house. I think that would potentially involve things like spot checks, or the regulator would hear a complaint and would say, gee, you're just not doing a great job. That would be something different from the firm itself, that somehow the firm isn't operating under its, essentially the license that the Sandbox gave them, I suppose. But
yeah, well, maybe the way to say it is we're regulating the entity and the services that entity provides. To use your analogy, I don't think we would want to be worried about whether it was employee A or employee B of the entity that was involved in giving the mistaken advice. That's just what I mean. That's the distinction, I think.
Okay. That makes sense. I mean, if there was something that if this was an attorney and they violated the rules, then would you conceptualize that as a referral situation from a regulator perspective?
I suppose so. I mean, if it came to the Sandbox regulator's attention that there was some sort of a problem with the lawyer disciplinary point, what we've tried to make clear in Utah is we're not going to regulate the lawyers to the extent they need to comply with the rules of professional conduct. There's a whole different structure. We heard about those folks, this morning. So I don't know. I guess that could be a concept that the Sandbox regulator would have be expected to, just like all lawyers, give notification to the disciplinary council if they saw something that warranted it.
Yeah, that seems reasonable to me. But okay, thank you. That's very helpful.
Any other questions or comments on this proposal?
So do we take that general silence as this seems like the right direction for us to go, or what should we do with that?
I'm going to call this last call. If you think this is not the right direction, please raise your hand and express what your concern, misgiving, hesitation might be. David Engstrom has something to say.
Sure, John, I just wanted to be sure that this wouldn't preclude an intervention in which an entity that is providing two very different types of services is told that it can't continue to provide one of those services because it's raising concerns, whereas the other is uncontroversial and is raising no concerns as to consumer harm. Like we're not imagining that you're either in or you're out. We can imagine a set of interventions where we kind of unbundle a set of services that an entity provides for regulatory purposes.
That seems reasonable. I mean, to apply that concept, if somebody were permitted to use non-lawyers for part of what they were providing in the way of legal services, and was also a partly owned by non-lawyer entity, and a problem surfaced with how their non-lawyers were providing the services, it seems like you could, as the regulator, suspend their right to have non-lawyers doing services, even while whatever they were doing, what else they were doing continued. Is that what you have in mind? Something like that?
Yeah, that's right. I just wanted to be sure that by agreeing to an entity level regulatory approach, that we weren't foreclosing that possibility, that you could slice and dice what an entity is doing.
Right. I suppose another example is it turns out there's a problem with some algorithm they're using, and we need to stop them from using that algorithm, but there's some other service they're doing that doesn't involve the algorithm. I mean, it underscores, I think, the need to be kind of flexible as to what that range of authority is.
And I think you kicked us off, John, by talking about entities and the services they provide. So that's a nice rounded version of it. Before we get to the next commenter, I want to just thank Brady for posting in the chat the AG Opinion site from our conversation a few minutes ago. It's there now. Randy, you're next.
Oh, thank you. So I think we did hear from the enforcement staff about the distinction between disciplinary authority over an entity regulation, also known as law firm discipline, as it was in vogue to refer to it many, many years ago, that is not currently within sort of the tools that we have for regulating the practice of law by individual lawyers. But if we are talking about the variety of applicants to a sandbox, it could be a law firm, could be an individual lawyer, could be an individual non-lawyer, it could be an organization comprised of either or both. And I think when we look to the model of alternative business structures that has an inherent entity regulation, some of those types of regulations imposed when they're admitted to these types of pilot environments would be to force the organization to identify individuals for the regulator. And so the head of legal services or the head of operations or the chief financial officer, and require them to be individually held to certain standards as the condition for being able to participate in the sandbox. So it seems to me that if Supreme Court issued an order authorizing an organization to be admitted as a provider, that could be a consideration in terms of how the regulation is actually imposed. Do we need to identify, in addition to saying, well, the provider is the organization, but we also need specific individuals, whatever title they have, to be identified for regulatory purposes.
Yeah, that brings to mind to me the SEC's way of regulating, disclosure statements. It's regulating the entity, the publicly traded entity, but there's a chief financial officer that has to sign that disclosure, and they do so with consequences if there's a problem with it.
Tom, is your hand raised or is that a legacy?
No, I was just going to mention that that's also analogous to what the United Kingdom does, because there's a head of practice who is the responsible party for making sure that the rules are followed within his or her purview. So I think that's analogous to what Randy's talking about.
So it sounds like in part of maybe fleshing this out, although the focus would be on the entity, we need to contemplate this idea that there's some accountable party within the entity, individual within the entity, as part of what we work through.
Yeah,
I do think there's some interest in, we've heard some interest in that, whether it's called a head of practice or a chief sandbox officer or whatever.
Right. Arizona has that to a degree. They have this idea that there's a lawyer that's a compliance person. It's a next level to say this person that's individually responsible or accountable for what the entity does must be a lawyer. That's a next level kind of question, I think.
That's a very interesting question. I don't know if you want us to discuss it now or if you are flagging it as something you will be fleshing out and bringing back. But I think that's a very important thing it's a question we should at some point have a view on.
Probably the latter, unless somebody has something they want to say about it.
Then I think we can move to whatever I think you had another topic to raise.
No, I think this was really it.
Aha, okay, well then we will move 5 minutes ahead of schedule to return. Actually, yeah, let's move now to the scope topic. I realize we've gone a long time without a break. On the other hand, we are scheduled to break at 4:30. So if we can turn it over to Becky and Tom to lead us through the issues that they consider most important to get group feedback on for Scope's work.
So, because we're going to need to, you're going to tell us our next steps. We're going to get assignments, so we're not going to take a full 35 minutes here. Tom, what I would like to propose is we just take a few minutes and ask if anyone has anything left over from the first conversation about scope that we had before Jillian and the bar folks came that you want to raise. And then I think Tom has a revised mission statement prepared.
Yeah, I think from my perspective, Becky, I think that makes a lot of sense. We got a lot of feedback at a high level, and we're going to go back to this process as a group fairly quickly. So yeah, I think that would be fine.
May I raise an issue that was a scope issue that came out of Jillian's presentation rather than from before, but I would really like to have an answer from this group. And it comes from the question I asked her. Does this group anticipate that a limitation on the scope of what we can do, what we are authorizing, is that we are not authorizing non-lawyers to appear in court? Because that seemed to be what she was assuming, and that was not something that we have specifically aired as a restriction on, you know, if we're going to consider opening up the regulatory doors and changing, you know, allowing anybody in the sandbox, are we going to let into the sandbox someone who says, I'm not a lawyer, but I am really well trained and am an expert and therefore should be able to represent my customers or clients in their, I mean, family law hearings, tenant right hearings, or jury trials?
I think just a preliminary view, because I think we probably need to think about this. I think under some circumstances that might be worth considering. I mean, I'm thinking about the New York example. So the New York bar has proposed that licensed social workers be able to go to court with their clients and sort of at least help out. I don't know that they're actually advocates or whether they provide more neutral information, but you know, I mean, there are some of these dockets which cry out for some help. And, you know, so I don't think I would personally preclude it at this point, but I think it's something we should leave open candidly, but one guy's view.
Okay, Micah.
I think we should preclude it. I think that what Tom may have been referring to is some sort of support person. For example, DA's offices have victims advocates. In most of my cases, there's a criminal component and there's someone who works for the DA's office who's there to help the client speak in court to feel comfortable. I think something, you know, a role like that with the proper education and training is fine. I think when someone is making an appearance and advocating and presenting legal arguments, they should have to be an attorney. And I think that the amount of, and not that this is a reason not to do it, but the amount of changes to statutes and, you know, trying to figure out how we can mimic or mirror all of the duties that lawyers have to clients for a non-lawyer, I think that it's going to be kind of a fool's errand, and we should really stick to what we can do to help. And I don't think allowing non-lawyers to advocate in court is going to be something that will be well received from the legislature or the Supreme Court.
Jim.
I was surprised to hear Jillian say what she did. I don't think we've expressed any view on that. And I worry about getting out of our lane relative to the work of the paraprofessional committee. I wouldn't want to do something here that's inconsistent with what the paraprofessional committee might authorize, where they say a paraprofessional can, under some circumstances, go into court, and we say, oh, but if you're in the sandbox, you can't have such a creature.
Let me respond directly to that, because I may have spoken inartfully, and this also addresses the earlier question about, I think Micah asked about how our work relates to their work. I didn't mean to suggest that we would in any way veto their licensing, but given John's point about how we're licensing entities, not individuals, what I was thinking about was, does an entity license allow an entity to send anybody into court who is not sufficiently licensed to do it? So mostly we're used to thinking of that as a lawyer, but obviously if we do get a paraprofessional working group recommendation enacted into law that says, let's pretend anything but a jury trial in family law, well, actually there are no jury trials in family law. So anything in family law could be done by a family law licensed paraprofessional. Let's say that's the law that the paraprofessional group advocates for and that they're successful in getting that reform. I don't mean to suggest that that a sandbox entity couldn't have family law paraprofessionals as professionals in the organization. I'm just saying, are we signing up for a restriction on the scope of an entity license that it allows, what we think of as UPL in the context of non-courtroom conduct, but not UPL in the context of courtroom conduct? Do you understand my attempt to clarify what I asked?
Yes, I think I might put it the other way, that I hadn't envisioned that by authorizing an entity, we would be permitting a non-lawyer with the entity to engage in what would otherwise be the unauthorized practice of law. A person affiliated with the entity.
You mean in, because I think that very much our discussion has included that entities would be allowed to have people engage in.
Yes,
what
you're
we
talking
call the
talking about court.
Okay, so if for you, you think court should, as Micah, I think, advocated, you think making an appearance in court should be beyond the scope of an entity license, if you will? That is to say, having somebody who's not otherwise licensed to appear in court appear would be beyond the scope of an entity license? I didn't say that well.
Yes, but I want to leave room for the recommendation of the paraprofessional committee to permit a licensed paraprofessional to go into court in a representative capacity under some circumstances.
I don't think anybody is suggesting we would do anything to countermand that.
Okay.
But I did see there were also a lot of questions or comments on this subject, so I'm just going to go down the list on this subject. Becky.
So there are already contexts in which we allow people who are not attorneys to represent folks in all kinds of federal situations, and then situations that are sort of federal state hybrids. And we already have an example of entity regulation, which is when Catholic Social Services is approved by the Federal Immigration Office to hire nuns to represent immigrants in proceedings. So I think we have an evidence base that tells us whether or not this works, and we're comfortable with it, and we have models for how to do it. So I would just observe that.
Thank you. Kevin. You're on mute, I'm afraid, Kevin.
Sorry, what I was trying to say is John and Andrew are ahead of me, so I prefer.
I see. Well, let's do John and Andrew and then come back to Kevin.
Thank you.
Just quickly, after a few dozen applicants, we finally have somebody that's proposed having non-lawyers actually appear in court in Utah. And it does feel different to some of the points Micah made, that, it just invokes a whole different set of rules and procedures. We're concerned about what the trial court benches are going to, how they would react to that, which is sort of their domain, so to speak. And that, at best, we may be able to sort of have a pilot. The proposal is to use the third-year practice rule and some other, variants on that in order to try that, but it would be with kind of limited hearings and non-dispositive, kind of just, again, easing into it. But I think that there is something qualitatively different, it seems like, about having people step into the courtrooms that are otherwise been the place that lawyers work. So it is, I think, a more difficult task than other things.
Your reference to the third-year practice law rule, I don't know the full scope of it, but I do know in California we have law students who appear in criminal courtroom and argue certain aspects of a case. I think they can even try an entire case as long as there's an attorney supervising them. So I didn't mean, in talking about lawyers or even lawyers plus paraprofessionals, to be excluding anybody else who is otherwise separately authorized. Andrew.
I would, building on what Rebecca said, I would just say that I think we should, in my view, kind of consider the possibility of expanding non-lawyers representing people in different contexts. If we already have it occurring in ways that are okay and that we've seen through evidence-based approaches is it works. A wonderful thing about the sandbox could be to try other places where that might be a good fit, landlord tenant issues, et cetera. And I think in my view, and perhaps it's more of just kind of the way I view the sandbox, it should be a place where we, have failures as well. There might be a situation where someone goes and represents and there is a problem, and that would identify where it wouldn't work moving forward. So I just, oftentimes in law, we try to craft things to be perfect, but in my idea, the sandbox could also prove things that aren't great. And if the consumer accepts that risk and there's enough information and both parties consent, I think in the sandbox scenario, I think we should almost kind of allow almost anything to occur, provide, and then afterwards also as a community deal with, hey, that was a bad idea, that didn't work well, or hey, that did work well. How are we going to find out if something can work really well if we don't allow it and track it and get the data from it to begin with? It seems like it would be not an ideal situation to go that route either. So for me, I would love to allow, if I had a legal issue, a non-lawyer to probably represent me in court. Might not go very well, but that would be a risk that I would be willing to take on and probably, be a trailblazer to get that data.
And if you were a shy and retiring or even traumatized litigant, you might be even more willing to have somebody take on the role of speaking for you, even knowing that he or she was not licensed.
Or someone who English is not their primary language. I think oftentimes we forget about the fact that immigrant communities come from socioeconomic backgrounds where $150,000 in law school debt is just not a possibility. Maybe even going to college isn't a possibility. Therefore, the end result is people who don't look like you and you can't afford them. So I think there's a lot of context here. And by just having that just blanket rule, I think it goes against what the spirit of a sandbox should be. It should be a place where, yes, guess what? There are going to be things that happen in the sandbox. And for those who are detractors and said we shouldn't have done that, great, hooray, use that data to prove whatever you want to prove. But let's get that data. Let's allow people to have that occur. And then using that data, let's make informed decisions moving forward from that.
Kevin.
Okay, I think this question is a lot more complicated than what we've been discussing, because the paraprofessional working group is proposing that paraprofessionals will be able to appear in court. They are going to have strict admission requirements to be able to become licensed as paraprofessionals. I don't want to interfere with the paraprofessional working group regulatory authority, however they're going to set it up, by having a secondary tier. It's just going to be confusing if we were to have two lines by which people might appear in court. We haven't even spoken about what qualifications must a person have to appear in court. And you might refer to the federal agencies and so forth that might permit it. California has been reluctant to go as far as going into court and allow it in court. We now have the paraprofessional working group that is going to have various and sundry, my understanding, the last I saw, where they're going to have pilot projects in certain counties. Maybe that's changed since I last looked at their proposals, their draft proposals. And I just think it would create too much confusion for us to start doing this until we have a better handle on what the paraprofessional working group is proposing. So I would say, don't take it off the table, but before we go ahead, go full force. Let's wait and find out what the paraprofessional working group is going to be doing.
Randy.
So if there was one thing that might be considered for, I'll use Kevin's words, taking it off the table in terms of a sandbox applicant being able to submit a proposal for the delivery of in-court legal services, I would say it's in regards to delivery systems that are technology driven. And so both of our written comments that we received for this meeting emphasize that the sandbox application process is supposed to encourage all sorts of innovative delivery systems, including things that are technology driven. And so when I say if there might be something to take off the table in regards to in-court services, this came up at ADLS, and I don't think anyone is really so cutting edge that we think that we could authorize Alexa or Siri to be your of record advocate in a proceeding. And so if it's an order issued by the California Supreme Court to suspend or modify unauthorized practice of law for a technology-driven delivery system, maybe a legal advice device, then I don't think putting a barrier, a clear bright line limit that says, well, for technology-driven, if there's no individual actually providing it, then no in-court representation is permitted. When that came before ADLS, there were side discussions from some of our, very, forward-thinking, future-thinking folks that if there is going to be a technology-driven justice gap solution for in-court services, then it might be the result of court reform, in particular online dispute resolution. And so if you've ever had an eBay transaction go south, you know that online dispute resolution is the model there, and that it tends to be sort of invisible, but also very effective from my experience. And so if technology-driven innovation is going to hold a promise for litigation type dispute resolution, then it might be something for a completely different task force or working group to look at in terms of dispute resolution reform, particular exploration of online dispute resolution, as opposed to letting a provider with a technology-driven proposal, again, allow Siri or Alexa to go to court for you.
Thank you. Bridget.
I was just going to say, I'm not sure we're at a point where we need to limit it yet. I would just say, I think it's something to keep in mind, but at this point, just especially given our conversation with Jillian this morning, I just don't know if we need to be making any kinds of decisions to just cut that off the table right now. Excuse me.
So thank you. Let's move the conversation back to, unless there were any other things left over from this morning, to the next thing Tom wants to bring forward. Randy, is your hand up on purpose, or is that a legacy? Okay, thanks.
All right.
So Tom, over to you. And you can command the screen if you want us to look at text. But you're on mute.
That should just blink when you start talking. My apologies. So we were asked to try and scriven a bit with respect to the mission statement, and our apologies, my apologies, for not getting this to you sooner. So we'd like your input. So if Mimi could bring up the text we shared with her, that would be great. So basically, in terms of the text here, what we've done is given the thing you saw before a little bit of a sandpaper in terms of cleaning up some of the text. And we've also pulled a couple of things from the Utah document, which I liked as a model. So what's new here is in the second line, we talk about the sandbox candidate being able to demonstrate the capacity, or the sandbox.
Excuse me, could you increase the size of the document on the screen?
Thank you, Kevin.
Yeah, that's good. So the text in the second line with one small difference comes from Utah. The other change is that instead of saying something like things that are not within the purview of the rules currently, et cetera, we just use this as another piece from Utah. Talk about the public interest will be served by allowing non-traditional legal service providers to show that, and so on. So I realize this is coming to you late in a very long day, but if folks have reactions to this, and certainly members of the scope subcommittee will have the opportunity to look at this in more detail next time we meet. But we just wanted to give you a sense of the kind of things we're thinking about and your insight and input even from a preliminary perspective would be helpful. And Becky, do you want to say a few words about this? Or
I think you did a great job, Tom.
Oh.
Thank you.
Okay, Micah has a comment and then Andrew.
Yeah, I think I would feel a lot more comfortable with this if it were proposed as something we were going to analyze and determine whether or not to recommend things to the legislature or the Supreme Court. This is saying something in the affirmative, like it's a foregone conclusion. I went back to look at what the State Bar had published on its website about what the task force in general is meant to do. And there's 3 different provisions and they all talk about whether to do something and how it can be done in the context of public protection. Every single one of the 3 charges listed included public protection and how or whether a goal could be accomplished in that context. And to my taste, we haven't been talking about public protection enough. So I would just prefer to see the language be more of a, if and when, or when or whether, rather than a foregone conclusion.
Thank
Yeah,
you. I think whether one way of accomplishing that is to say the purpose of the proposed sandbox.
yeah, I think that's right. And I think the idea of public protection seems to be implicit here, but we could certainly, I think I wouldn't want to drop it in at this very moment, but I think the term public protection could certainly be included here.
Yeah, it might make sense to send around in a Word document and people can track changes or something like that. I don't know if that's allowed under the Brown Act. It probably is, but I just really think we need to get that back into our normal everyday conversation on this committee, that's what we're trying to do.
Yeah, no, I think that might be helpful.
I think that's a helpful point. And given the hour, I'm going to, I apologize for having made a specific suggestion. I'm going to just go through and let everybody say what they want to say in response to this. And then the scope committee has already said they will go back and look at it more carefully. So Andrew, did you have something you wanted to share?
Yeah, I would just add something to the effect of gather data as a goal in order to kind of gather data for future decisions or future legislative changes or future this or future that, but that's an important aspect I think is missing.
Okay, yeah, point well taken.
Because we're screen sharing, I don't see everybody's picture. If your hand was raised or you have a comment and I haven't called on you, please just call out.
While we're waiting, Mimi, would you add the point that Micah made about public protection? That we add text Yeah, that's good.
Okay. If there are no other comments specifically on this subject at this time, then I think I will move us forward to wrapping up because it is almost 4:30. Oh, Kathy Huang has a comment. Could we add a point that the purpose is to provide recommendations but not implement these recommendations from this group? Okay. Thank you, Kathy. Are there any other comments or questions on this subject? John Lund.
I'd just like to quickly give a little pushback on this concern about public perception. We heard that there's a huge portion of the public that are not getting representation at all. And so in terms of public interest, I think we have a lot of people being harmed by not having legal services at all. So I'd be concerned that we don't clamp down this concept around the sandbox so tightly that we continue to guarantee a huge portion of the population will not be able to have legal representation at all.
Thank you. Micah has a comment.
Yeah, I mean, I disagree, and there's a whole group of people in the state that disagree with the interpretations. So I don't think that's a foregone conclusion with everyone. And my only point was, it wasn't about public perception. So I don't know if you misspoke. So I just want to be clear. It's about public protection, and it's what the Board of Trustees charged us with. So I think we have to balance everything. But we have to do it in a way to ensure that we are continuing to protect the public.
Bridget.
I think that's fine, but I also was just going to say, I think it is implicit in the competent, affordable legal service. Competent is in there. So I mean, I think our whole discussion has been about public protection. I really disagree that we haven't talked about it. I think that's at the top of our minds this whole time. So anyway, side note.
Yeah. Okay.
Okay. Unless any of the committee co-chairs have something that they feel we need to do in the last minutes, I'm going to draw our meeting to a close. Someone pointed out that it's my task to talk about next steps. I'm going to remind you, your next step is to volunteer for one of the rules-related assignments for September, if you're able and willing, by email to bar staff and/or to me. That the subcommittees have meetings planned coming up. I'm not exactly sure when, and we have a next meeting at a date I'm not exactly sure when, but I think those dates are all on everybody's calendars. If anyone has any questions about those or about next steps, please raise them now.
One quick comment, Justice Tuger, is that there are going to be some things I think sent around in follow-up to this meeting, and any member of the working group who wants to sort of respond or provide input, we ask that you just send it to staff and just tell us if you want that input to go to the SAGE committee or to the scope committee or to all the members, because we do have a little bit of a hiatus until the next full working group meeting. And in that time, you may be looking at some of the stuff. You may have some ideas and feedback you want to give, but we don't want you to start sending things around to each other. Send it to staff, tell us how you want it distributed, and we'll get that sent over.
And can I ask you a question then relating to distribution? The things that people have put into the chat, like the cite to the Attorney General's opinion, or the slides from Professor Hadfield's presentation and from the State Bar presentations, are those things either in or they will be added to the meeting materials so that that's the way we would find them if we want to look for them later? Or would they be separately emailed around? Because while it's been very helpful to have things in the chat, I think the chat will disappear when the meeting ends. And so I would like to make sure that people know how to find the different materials that we've had been pointed towards, or the slides from today's presentation.
Let me just ask if Lauren and Mimi are on the line still. Did we receive the presentation slides from each of the speakers today? I mean, do we have them already?
We have the slides. This is Lauren from the Office of Chief Trial Counsel staff, and we are working to obtain Professor Hadfield's. And I'm right now grabbing what I can from the chat and plugging it into my notes version before the meeting is closed out.
Super. Thank you, Lauren. I appreciate that.
Sure.
So we can either upload to the OneDrive, or we can just send it out by email. It's no trouble to compile these few things and send them out by email as well.
Well, maybe both would be great. That way they'll be handy for people who want to see them now and available for people who want to dig them out later.
One other reminder is that after a bit of time has passed, the archive recording of the Zoom meeting that includes the presentations are uploaded eventually to the CalBAR's YouTube account that allows people to go and watch. If you want to refresh your recollection in preparation for your subcommittee meeting, or if you want to play something back because it was kind of heady and you want to think harder on it, then that is an option as well. You can go watch the archive video.
Super. Well, a lot of hard work went into preparing for today and a lot of good discussion happened today. So thank you everybody for your hard work. Stay cool, stay engaged, and we will see all of you at the next CTJG meeting in a couple of months. Take care. Bye-bye.
Thanks, Justice Tucker.
Bye all.